Okay, good morning, good afternoon, good evening, whatever the case may be. Hello, welcome to class. Today we are going to look at fair comment. We're still looking at fair comment, the defense of fair comment, and that would, we're using the text Clerk and Lindsell, and that would take us to, after fair comment, we are going then on to fair comment, the basic element. So how can you tell if something is fair comment or not? Okay, and then we will do some more later on. Okay, so let's begin.
Chapter 22, Defamation. Section 6. Defenses. Subsection D. Fair comment. Defense of fair comment. 22 to 164. The defense of fair comment protects statements of opinion or comment on matters in the public interest. The principles upon which this protection rests have been a matter of some controversy. Some lawyers were of the opinion that the defense of fair comment should be regarded as a branch of qualified privilege. However, the modern approach is to consider it as a separate defense with no relationship with privilege. The distinction between the two defenses, privilege and fair comment, was pointed out by Lord Esher Mr. in Marivalli v. Carson 786, where he said, "A privileged occasion is one on which the privileged person is entitled to." Page 136. Do something which no one who is not within the privilege is entitled to do on that occasion. A person in such a position may say or write about another person things which no other person in the kingdom can be allowed to say or write. But, in the case of a criticism upon a published work, every person is entitled to do and is forbidden to do exactly the same things, and therefore the occasion is not privileged. In directing the jury in Silken v. Beaverbrook Newspapers Ltd 787, Diplock J. put it as, "The right of the public, which means you and me, and the newspaper editor, and the man who, but for the present bus strike, would be on the Clapham omnibus, to express their views honestly and fearlessly on matters of public interest, even though that involves strong criticism of the conduct of public people. Everyone has the right to comment within the limits of fair comment, whether he be writer, reporter, newspaper editor, or ordinary citizen, in a letter to a friend or by way of spoken comment." Fair comment basic elements. 22 to 165. The modern authoritative statement of the law of fair comment is to be found in Tsewe Chun Paul v. Albert Cheng 788, where, in the Court of Final Appeal of Hong Kong, Lord Nichols outlined the history and principles of the defense. The defendant must overcome 4 hurdles in order to establish the defense. 1. The statement must be comment and not fact. 789. 2. The comment must have a sufficient factual basis, that is, the comment must be based on facts which are themselves sufficiently true. 3. The comment must be objectively fair, i.e. it must be an opinion which an honest person could hold. This is an objective test, but should not be confused with reasonableness. 4. The subject matter of the comment must be of public interest. Where these are surmounted, the defense will succeed unless the claimant proves that the comment was maliciously published. Malice in this sense is addressed at para. 22-176. In Joseph v. Spiller 2010 UKSC 53, 2011 1 AC 852, the Supreme Court ruled that it was not a prerequisite of the defense of honest or fair comment that the readers should be in a position to evaluate the comment for themselves, as suggested by Lord Nichols in Tsewe Chun Paul v. Cheng 2001 EMLR 31. In modern times, with the amount of information on the internet, it would often be impossible for readers to evaluate defamatory comments without detailed information about the facts which had given rise to the comments. The proposition that the comment must identify the matters on which it is based with sufficient particularity to enable the reader to judge for himself whether it was well-founded was wrong. What was required was that the comment identified, at least in general terms,
the facts on which it was based.
Barrel waiting for the final gates to open to a new tomorrow, moving with the motion, following the light that sets me
Okay, let's just take a look at some notes, read some of these notes. All right, but before we do that, let's just recap fair comment basic elements. Defense of fair comment. The defense of fair comment protects statement of opinion or comment on matters of public interest, right? Now, the fair comment has to be, here are the basic elements of fair comment. The modern authoritative statement of the law of fair comment is to be found in Che Y Chun Paul V. Albert Cheng, where in the Court of Final Appeal of Hong Kong, Lord Nichols outlined the history and principles of the defense. The defendant must overcome 4 hurdles in order to establish the defense. The statement must be comment and not fact. The comment must have a sufficient factual basis. That is, the comment must be based on facts which are themselves sufficiently true. The comment must be objectively fair. That is, it must be an opinion which an honest person could hold. This is an objective test, but should not be confused with reasonableness. The subject matter of the comment must be of public interest. Where these are surmounted, the defense will succeed unless the claimant proves that the comment was maliciously published. Malice in the sense is addressed at paragraph 22 to 176. In Joseph V. Spiller, the Supreme Court ruled that it was not a prerequisite of the defense of honest or fair comment that the reader should be in a position to evaluate the comment for themselves as suggested by Lord Nichols. In modern times, with the amount of information on the internet, it would often be impossible for readers to evaluate defamatory comments without detailed information about the facts which had given rise to the comment. The proposition that the comment must identify the matters on which it is based with sufficient particularity to enable the reader to judge for himself whether it was well-founded was wrong. What was required was that the comment identified, at least in general terms, the fact on which it was based. Okay, so let's look at the note. And EDJ and Bronson v. Bauer acknowledged that Cheng is merely a persuasive authority but recognized its importance. He also applied it in the case of Sugar v. Associated Newspapers and reported February 6, 2001, and it cited with approval in the single meaning doctrine applies to cases where the defense of fair comment is relied upon. See Low v. Times newspapers, where the court observed that it would be hopelessly impractical to judge the validity of the fair comment defense by reference to what the author of the words had intended, thought, or hoped the words might convey. The first step is to identify the meaning of the words and then decide whether the defense of fair comment has been established. Okay, so we'll move on now to comment, not fact. Fact or comment, right? So how do you know something is a fact? How do you know something is a comment? Okay, so we go to on pages 137 to 140. Right, from 137 to 140. Let's do it.
Main volume. Chapter 22, Defamation. Section 6. Defenses. Subsection
D. Fair comment. Subsection I. Comment not fact. Fact or comment. 22 to 166. Whether a statement is fact or comment can be a very difficult distinction, particularly because in many publications there is a mixture of both. There is no statutory definition of fact and comment. The following principles can be derived from the decided cases. 1. In Branson v. Bauer, number 1, 790 Latham L.J. approved the judgment of Cusson J. in Clark v. Norton 791 where he said, more accurately it has been said that the sense of comment is something which is or can reasonably be inferred to be a deduction, inference, conclusion, criticism, remark, observation, etc. 2. Where the statement is a pure value judgment, incapable of proof, it is likely to be regarded as a comment. For example, the suggestion that a critic is completely out of touch with the tastes and entertainment requirements of the picture-going public is a matter of judgment and is clearly a comment. 792 In British Chiropractic Association v Singh 793 the claimant sued over the claim in a newspaper article that the BCA happily promote bogus treatments by chiropractors, even though there was not a jot of evidence to support claims that such treatments could be effective against a number of children's ailments. The Court of Appeal reversed the decision of the judge and concluded that such a statement, appearing on the comment and debate page of the newspaper, was a value judgment rather than an allegation of fact. The allegation amounted to an evaluation of published material as giving no evidential support to a claim, and that was a matter for page 138. Scientific opinion. 3. Where the defendant refers to certain facts and makes it clear that the statement in question is an inference from the facts, it will generally be considered comment. 794 This technique is often utilized by the makers of documentaries, who might set out a number of facts from which they draw the conclusion that the claimant is, for example, unfit for public office. The conclusion will clearly be comment. However, it is vital to bear in mind that where the preceding matters are defamatory statements of fact in their own right, they will have to be justified, i.e. proved true or substantially true. 795. 4. A bald statement with no supporting facts is unlikely to be considered a comment. 796. To say that C is a disgrace to the profession of journalism may sound like an opinion, but, in the absence of any indication of the basis for the statement, it is likely to be treated as a statement of fact. To say that C disclosed the identity of his source and is therefore a disgrace to the profession of journalism clearly identifies the latter allegation as comment based on the fact that he has disclosed his source. Kemsley v. Foot 797 concerned an article in Tribune which attacked the conduct of the Evening Standard and its proprietor Lord Beaverbrook. The article was headed lower than Kemsley, referring to the claimant who was also a newspaper proprietor. There was no other reference to the claimant and his name was simply used as a comparison. The House of Lords held that the headline was capable of being understood as comment, namely that the Kemsley press was of a low and undesirable quality and that Lord Kemsley was responsible for its tone. The supporting facts were the claimant's ownership and control of popular newspapers and the standards and ethics of those newspapers. Although these facts were not referred to directly in the publication, they were sufficiently indicated to be understood by reasonable readers to be the facts on which the comment was based. 5. The defense of fair comment is not limited to pure value judgments. A statement which appears to be factual and which is either true or false, may nevertheless be regarded as a comment where it is apparent that it is an inference drawn from other facts. This issue arises most commonly where the defendant has attributed an improper motive to the claimant. The traditional view, to use the words of Bowen L.J. in Edgington v. Fitzmaurice 798, is that the state of a man's mind is as much a fact as the state of his digestion. However, it is now clear that such allegations will often be regarded as statements of opinion. In Branson v. Bauer, No. 1, 799, the claimant, Sir Richard Branson, complained about 4 paragraphs of an article published by the defendant in the Evening Standard. The article appeared a day after the claimant had made a speech explaining his lottery bid, in which he had said that the lottery as run by him would be structurally separate from Virgin. The article was entitled "Why We Should Be Less Charitable to Branson." It discussed the claimant's suitability to run the national lottery. It was in hard-hitting terms, discussing among other things how revenge against Camelot had motivated the bid, rather than the claimant's self-righteousness. The meaning contended for by the claimant was that he was using his promise of a private charity fund to disguise his true intention to promote Virgin, and that he was a hypocrite, motivated by revenge and self-interest rather than charity. The defendant argued that the article was comment, and that the allegations made were value judgments or imputations of motive or intention, which were akin to value judgments. It was contended that to require a defendant to have to prove the truth of value judgments would be an infringement of Art. 10 of the ECHR. EDJ agreed, concluding that the traditional English view in Edgington had been affected by recent developments in the law. He said, more. Page 139. Recently, however, the courts have been readier to treat the attribution of motive, in some cases, as matters of inference or comment. In the end, however, any such classification must depend upon the words actually used and upon their context. The Court of Appeal upheld the judge's finding and his reasons given. 800 in Keys v. Guardian Newspapers Ltd. 801. The claimant, the former mistress of Lord Parkinson, complained over an article in the comments section of The Observer which was entitled "The Mother of All Women Scorned." There was a bold headline underneath stating the vituperative Sarah Keys has enlisted her damaged daughter to her cause. The article, a column, chronicled the distasteful showing of the previous week, in which the claimant and her daughter, by Lord Parkinson, had appeared in television and newspaper interviews. The claimant complained that the newspaper accused her of cynically using her daughter to get back at Lord Parkinson by allowing her to give interviews to which she could not properly consent. She also complained over the statement in the article that she had given a kiss and tell story to the Sunday Times in 1982, when she was pregnant with Flora. The defendants argued that the article was capable only of being comment. former mistress of Lord Parkinson, complained over an article in the comments section of The Observer which was entitled "The Mother of All Women Scorned." There was a bold headline underneath stating the vituperative Sarah Keyes has enlisted her damaged daughter to her cause. The article, a column, chronicled the distasteful showing of the previous week, in which the claimant and her daughter, by Lord Parkinson, had appeared in television and newspaper interviews. The claimant complained that the newspaper accused her of cynically using her daughter to get back at Lord Parkinson by allowing her to give interviews to which she could not properly consent. She also complained over the statement in the article that she had given a kiss and tell story to the Sunday Times in 1982, when she was pregnant with Flora. The defendants argued that the article was capable only of being comment. EDJ agreed, stating that the article bore the unmistakable badge of comment. He therefore withdrew the issue of whether the article was fact or comment from the jury, observing that any jury deciding that the article was factual would be perverse. He observed that the article was clearly in the comment section of the newspaper, and had the appearance of drawing inferences as to fact or motivation from the surrounding context. In the circumstances he had no hesitation in ruling that the article was comment. 6. In contrast, a statement to the effect that a claimant has been guilty of a particular act is likely to be considered factual unless it is apparent that it is merely an inference drawn from other facts. To say of a composer that he organized the wrecking of concerts is a statement of fact which can only be justified. 802 Likewise, the allegation that the claimants have been party to a plot to force the end of a play is either true or false and is a statement of fact. 803. 7. The context in which the statement appears is relevant. Bold headlines and assertions in news stories are more likely to be considered statements of fact. 804 Whereas criticisms in leader articles, letters, or personal columns are more likely to be considered comment. The reader understands that the statements represent the personal views of the columnist. Prefacing statements with the words "in my opinion" or "in my judgment" may help, but is not necessary if it is clear from the context that they are comment. 805 A similar principle applies to reviews of products or literary, dramatic, or musical works. 806 These inevitably involve the subjective evaluation of the reviewer. Humor is also more likely to be considered to be comment, albeit exaggerated and prejudiced. It is sometimes claimed by a claimant's advocate that mere vituperation or invective is not comment. Such a submission was advanced in relation to a newspaper review of the performance of an actress which included the suggestion that her bum is too big. However, in cases of vituperation the closest alternative to comment is vulgar abuse, which does not appear to get the claimant any further. 807 Moreover, both English and European cases recognize the right to use strong language which may shock and cause offense. 808. 8. The words which are alleged to be comment must be stated within the publication. This is in contrast to the supporting facts. 09 The reader should be able to point to specific directly stated. Page 140. Directly stated. Page 140. 8. The words which are alleged to be comment must be stated within the publication. This is in contrast to the supporting facts, which need not be. Page 140. Directly stated. A comment cannot be an implication which the reader might draw from the publication but which is not stated. 809 The reader should be able to point to specific words in the publication and recognize them as comment. A defendant in his defense should generally identify the particular words of the publication which he alleges to be comment. Consideration may only be given to the 9. In deciding whether a statement is comment, consideration may only be given to the publication which is the subject matter of the claim and not other publications to which it refers. In Tulnikov v. Mitasevich 811 the claimant wrote an article in the Daily Telegraph following which the defendant wrote, and the newspaper published, a letter which was critical of the claimant's article. When read in the context of the original article the allegations in the letter were held to be clearly comment. However, the House of Lords held that the letter should be construed in isolation, on the ground that many readers of the letter would not have read or remembered the article. 10. where the defendant has failed to distinguish clearly between the facts on which he is commenting and the comment which he wishes to make, the statements may be regarded as factual. 812 Hence the importance of clearly identifying the comment. 11. Whether a statement is fact or comment is to be determined by how it would be understood by the ordinary reader. 813 In contrast to determining defamatory meaning, it may be that there is less scope for attributing loose thinking. 814 in Cook v. Telegraph Media Group Ltd 2011 EWHC 763, QB, the court concluded that the allegation that the claimant was a low-value MP was unarguably comment rather than a statement of fact. Also, an allegation that the claimant set out to exploit or abuse the expenses system for MPs was capable of being fact or comment. See also Cook v. Telegraph Media Group Ltd 2011 EWHC 1134.
Okay, let's just look at some notes. We're looking at notes now. So comments have to be clearly marked as comments, right? Okay, so the notes on this, very interesting. Branson, unreported. Okay, so I will leave the notes up to you at this stage because I'm not seeing any notes in the text that I need to highlight. As a student, you can do some research on the necessary notes. Okay. All right. All right. Let's get to it again. And 43. Okay, so we're taking it from here. We're taking it. We're continuing on page 141. Clerk and Lindsell, main volume, chapter 22, defamation, section 6, defenses, subsection D, fair comment, subsection 2, sufficient factual basis. Okay.
Main Volume. Chapter 22, Defamation. Section 6. Defenses. Subsection D. Fair comment. Subsection 2. Sufficient factual basis. A sufficient factual basis. 22 to 167. It is said that a comment cannot exist in thin air. The defendant must prove that the factual building blocks on which the comment is based are true, or sufficiently true. In the example given in point 3 above, the allegation that C has disclosed the identity of a source is the fact on which the opinion that he is a disgrace to journalism is based. If C did not, in fact, disclose the identity of a source, then the comment and the defense collapse. By analogy, it cannot be fair comment to attack an author for something he has not written. In Marivalli v. Carson 815, the defendant published a review of the claimant's play which suggested that it had an page 142 evil tendency on the basis that it treated adultery cavalierly. In fact, there was no mention of adultery in the play, and the defense of fair comment therefore failed. The following principles are relevant. 1. The facts must be either stated or summarized in the publication, or indicated with sufficient clarity to enable the publishees to ascertain the facts on which the comment is based. In Kemsley v. Foote, there were no supporting facts stated or summarized in the publication. However,
Readers would have had no difficulty in understanding the factual basis of the comment. In certain circumstances, a defendant is entitled to rely on extrinsic facts, i.e. not stated or indicated in the article, in support of a plea of fair comment. If there is a general public awareness of the subject matter, comment can be made without setting out in the article the facts on which the comment is based, provided that the subject matter of the comment is plainly stated. 816. 2. Where some of the facts stated in the publication are true and some are false, the defense will succeed if the defendant would have been entitled to make the same comment solely on the basis of the true facts. Section 6 of the Defamation Act 1952 states, in an action for libel or slander in respect of words consisting partly of allegations of fact and partly of expression of opinion, a defense of fair comment shall not fail by reason only that the truth of every allegation of fact is not proved if the expression of opinion is fair comment having regard to such of the facts alleged or referred to in the words complained of as are proved. Then S.5, which is the question is whether or not the factual building blocks remain sufficiently strong to justify the comment. It gives far greater leeway to defendants than S.5, which is the equivalent provision for justification. See Para. 22-82. Developing the earlier example, suppose D states that C, a journalist, disclosed the identity of a source, fabricated an article, and gave perjured evidence in a libel claim, and that in consequence he is a disgrace to journalism. The fact that the allegations of perjury and fabrication are false should not prevent the statement that C is a disgrace to journalism being protected by fair comment, provided that the allegation that he disclosed the identity of a source is true. 817. However, that does not mean that C's claim will fail. Where the facts are themselves defamatory, they must be justified. 818. The allegations of perjury and fabrication are clearly defamatory, and the truth of the betrayal of source allegation is unlikely to be substantial justification. Under the stricter let-off provision in S.5, the claimant would be entitled to damages for the false factual allegations of perjury and fabrication, but not for the suggestion that he is a disgrace, although an award by a jury may not reflect such fine distinctions. 3. Section 6 refers to facts alleged or referred to in the words complained of. However, there is a similar principle in Kemsley v. Foote cases, where the facts are not stated in the publication. The defense succeeds if the on matters which he carefully 4. 3. Section 6 refers to facts alleged or referred to in the words complained of. However, there is a similar principle in Kemsley v. Foote cases, where the facts are not stated in the publication. The defense succeeds if the comment can be considered fair on the basis of any of the facts on which the defendant is entitled to rely and which are proved to be true. 4. Where the supporting facts are protected by absolute or qualified privilege, the defense will succeed even where they are untrue. A publisher is therefore free to comment on matters which he fairly and accurately reports from court or parliamentary proceedings, even if the witness or member of parliament in question subsequently turns out to be mistaken. However, the defendant must ensure that the privileged report is fair and accurate. In Brent Walker v. Time Out 819, an article was published in Time Out magazine which made defamatory comments about George Walker and the public company of which he was chairman. One of the matters relied on by the defendants in trial of Mr. Walker in 19 support of the comment was page 143. Support of the comment was a statement made by a police officer during a criminal trial of Mr. Walker in 1956 that police investigations show that there was a much larger organization behind the thieves with a criminal brain at the top. It was held, on the facts, that merely to report what the police officer had said, albeit accurately, was not a fair report of the proceedings. The defendants were not therefore able to rely on the statement in support of the defamatory comments which they had directed at the claimants. 5. The omission of truly exculpatory facts will be as fatal as getting the stated facts wrong. If D states that C has been convicted of a crime and comments on this, without stating that the conviction was subsequently quashed, the comment will not be protected. 820. 6. Unlike justification, the defendant cannot rely on facts or matters taking place after the date of publication on which to base the comment. 821. Furthermore, there is some authority that the facts on which the defendant relies must also be known to him at the time. However, in Cohen v. Daily Telegraph, Lord Denning said, "A man may comment on existing facts without having them in the forefront of his mind at the time." This is generally held to be a preferable view. In Cook v. Telegraph Media Group Ltd 2011 EWHC 763, QB, the court also decided that where relevant facts were omitted from an article, this did not necessarily lead to a conclusion that the facts were not truly stated in the article, but rather might be relevant to the issue of honest belief. See also Levy Evening Standard Ltd 2010 EWHC 3239, QB. Affirm 2011 EWCA Civ 859. The claimant sued over an article that suggested that, because she, a former member of parliament, had put her name to a letter published in the Times newspaper that sought to defend the much criticized old system under which MPs had claimed expenses, she risked the ire of some. A basic fact in the article was wrong. The claimant was accused of having had to pay back £25,000 in expenses, although it was another MP that the newspaper had intended to refer to. Nevertheless, the defendant argued that the allegation was an honest comment since it could be based merely on the fact that, as an MP who had claimed under the old expenses system, it was inappropriate for her to seek to defend the old system. The claimant contended that such an argument was unreasonable. No reasonable person could be angry simply because the claimant had put her name to the letter. However, the court ruled that the had been accurately stated. See also Levy Evening Standard Ltd 2010 EWHC 3239, QB, Affirm 2011 EWCA Civ 859. The claimant sued over an article that suggested that, because she, a former member of parliament, had put her name to a letter published in the Times newspaper that sought to defend the much criticized old system under which MPs had claimed expenses, she risked the ire of some. A basic fact in the article was wrong. The claimant was accused of having had to pay back £25,000 in expenses, although it was another MP that the newspaper had intended to refer to. Nevertheless, the defendant argued that the allegation was an honest comment since it could be based merely on the fact that, as an MP who had claimed under the old expenses system, it was inappropriate for her to seek to defend the old system. The claimant contended that such an argument was unreasonable. No reasonable person could be angry simply because the claimant had put her name to the letter. However, the court ruled that the inclusion of the false allegation concerning the £25,000 claim did not preclude the defendant from succeeding in a defense of fair comment provided that the comment was fair in relation to the facts that had been accurately stated. Reasonableness was not the test. The comment defense was available because the claimant, by having taken advantage of the flawed expenses system, had forfeited the right to be heated on the topic of expenses. That was an opinion that could be honestly held, and the defense succeeded.
Okay. Okay. Okay, let's take a look at the notes. We have one very important item here that should be considered for the exam. By analogy, it happens to be in an analogy, but it's well stated. By analogy, it cannot be fair comment to attack an author for something he has not written. Okay, so let's make a note of that right now. How fast we can do that. Okay, so let's proceed. Sufficient factual basis. That's where we will continue next. Sufficient factual basis. Okay, sufficient factual basis. And that would be 167. 167. Okay. Okay, so we will proceed. We will continue next on a sufficient factual basis. So you want to read ahead pages 141 to 143. Okay, 141 to 143. That's where we'll continue. Okay, a sufficient factual basis.